You may proceed.
Thank you, Senator, and members of the committee. I want to express my appreciation for the opportunity to appear today, and I want to emphasize at the outset that having served before the Supreme Court for almost 60 years, I have no interest in attacking the court as an institution. Rather, what I'm trying to suggest is that the court, in this decision at least, has brought criticism on itself. The court has always been subject to criticism, sometimes fair and sometimes unfair. It was criticized for the Dred Scott decision, for Plessy against Ferguson, for the Korematsu decision. All of those decisions, I think, have been repudiated by history, although they were rendered by majorities of the court. So the issue is not, is the court above attack on the merits of its decisions? The issue is, as I think you understand, is the decision that's under discussion today one that deserves acquiescence or not? And my submission is that it does not. I explained in my prepared statement that the decision is profoundly wrong and it is profoundly dangerous. It's profoundly wrong for several reasons. Notably, the court did not find any textual support for the decision. Indeed, the text points exactly the opposite. The court could not find an apt precedent in support of the decision. The only reliance the court could come up with, as Senator Graham mentioned, was a decision by a 5-4 court to grant civil immunity from private damage suits. Seems to me pretty obvious to any lawyers, even not constitutional lawyers, that the difference between immunizing a president from prospective liability to private citizens suing about official actions is fundamentally different from immunizing a president from culpability for committing crimes brought for violation of the same public interest statutes that apply to everyone else. The court could not rely on any historical practice in favor of criminal immunity. In fact, the practice is exactly the opposite. I know from my own experience in the Watergate affair that President Nixon was under active criminal investigation for his role in the cover-up. President Clinton was, President Reagan was. At no time before 2024 did any serious lawyer, nor did any of those presidents, claim that there was any kind of immunity from criminal exposure for crimes committed in office, including crimes committed allegedly in the performance of official function. The only issue that was debated during the Nixon period was whether the president could be indicted while still in office. Everyone, including President Nixon and President Ford, in granting a pardon, concluded that the president could be indicted for official acts after he left office. Constitutional text points in that same direction. The impeachment clause says that any person, including the president, whether or not impeached, is liable for indictment, prosecution, and punishment. And that necessarily includes official acts, because the only offenses for which a person, including the president, may be impeached are official acts: bribery, treason, and what are described as other high crimes and misdemeanors. Those were understood when the Constitution was adopted to be maladministration or the improper and possibly criminal performance of official acts. That indeed is what the term bribery means: taking money to perform an official function. Text of the Constitution could not be clearer that a president is subject to indictment, trial, and punishment for that kind of improper, that is, illegal performance of an official function. My statement also goes into detail as to why this is a dangerous decision, not simply an erroneous one. It essentially licenses a president to abuse his power and to get away with it. Nothing could be further from the intent of the framers than to establish the kind of immunity that the king alone, the king who was the target of the the abuses identified in the Declaration of Independence. And it seems to me to beggar any sense of the history of our country to treat the President of the United States as having the kind of immunity that no other person in this state, in this country, has to commit crimes and get away with it. Thank you, sir.
Thank you, sir. Professor Mascott.
Good morning, Chairman Durbin, Ranking Member Graham, and members of the committee. Thank you for inviting us here today to testify about presidential immunity and the Supreme Court's consideration this summer of the Special Counsel's criminal prosecution of President Biden's predecessor and now political rival. As a federal courts and constitutional law professor and former DOJ official, I'm grateful for the opportunity to speak about the opinion in Trump versus United States and help explain its scope. First, it's important to point out that since the court handed down its opinion, a number of public statements and commentary have significantly mischaracterized the opinion's holding and its scope. Some of those overstatements have made their way into some of the prepared testimony before the committee today. And before the Senate can evaluate the merits of the opinion, it's important to discuss what it actually held. So I look forward to summarizing the outlines of the opinion in this opening statement. The justices were compelled to take the case because the special counsel within the Biden administration and DOJ decided to prosecute President Biden's predecessor, and the prosecution has continued into this current political season, where we now have the unprecedented situations of a former president facing prosecution by the DOJ he once supervised, and a sitting president prosecuting his current rival. Second, the Supreme Court opinion actually continued and sustained this matter, remanding it to the lower courts. That remand occurred because the court held the opposite of what many commentators and even witnesses here today said it held. The court held that former presidents can be prosecuted for criminal unofficial acts. Both the former president's lawyers and the government agreed on this point as it relates to unofficial conduct. They simply disagreed about when and to what degree and for what kinds of acts a former president can face criminal prosecution. The court's opinion in Trump versus United States divides the categories of criminal prosecution and acts that are presumptively immune into three buckets. The first bucket is unofficial acts that are subject to criminal prosecution. Notably, as my prepared statement points out in more detail, the Office of Legal Counsel within the Clinton administration in 2000 published a formal executive branch opinion suggesting the opposite while a president remains in office. The 2000 Clinton-era opinion concluded that even unofficial acts could not be subject to prosecution while a president remained in office. Rather, a president would have to be impeached and then convicted by this body or have his presidential term otherwise conclude for a prosecutor to indict or charge a president criminally for even official acts under the Clinton-era opinion. That 2000 opinion emphasized the incompatibility between criminal prosecution and potential jury conviction and the role of a sitting president. Importantly, the Clinton-era opinion is clearly based on an underlying doctrine of some kind of extensive presidential immunity. The Supreme Court in Trump versus United States addressed an extension or new application of this longstanding principle of presidential immunity. The court sets out two categories of potential immunity. The first represents a category that the court describes as involving core executive functions, and arguably this is a relatively modest subset. It involves functions for which a president historically has been understood to have complete discretion, areas that Congress lacks the power even to regulate, so it's very specialized. The courts list several areas: exercises of the pardon power, discretionary aspects of the removal power, and the power to recognize foreign sovereigns. And these categories do not extend nearly as far as some of the prepared testimony today suggests. The court's talking about the core, inner kernel of presidential authority and decision-making for which the president essentially has complete discretionary power. Decisions such as whom to nominate or fire or whom to pardon. Then there's the middle category that the court describes as extending to the outer perimeter of a president's executive functions. And in this area, the court does not definitively determine whether absolute or presumptive immunity applies. At a minimum, though, the prosecution would have to show an actions manifestly or palpably outside of presidential authority before bringing charges based on that action. And the court left many of the remaining details for the lower courts to work out on remand. Finally, one additional point. The institutional integrity and norms within each of the branches of government has faced repeated threats and challenges. Some are very recent, like attempted violence, and the New York Times report of yet another breach of confidentiality outside the longstanding norms of legal practice and service within the Supreme Court. Maintenance of longstanding norms of civility, humility in public service, principle, and integrity necessitates a sober approach to the characterization of governmental actions, and it involves taking a careful, studied look at the actions of fellow governmental servants. Thank you so much, and I look forward to the committee's questions.
Thank you, Professor Mascott. Professor McCord?